Digital Personal Data Protection or the DPDP Act is the top trending legal and tech topic in India right now because 2026 is officially the year of enforcement. While the Act was passed in 2023, it has moved from a theoretical policy to a high stakes reality for businesses and citizens alike. Here is why it is currently dominating the headlines. The government notified the final DPDP rules in late 2025, triggering an 18-month phased implementation. We are currently in the middle of this build year where companies must overhaul their systems or face massive penalties. The registration for third-party consent managers and entities that help you manage all your data permissions in one place began recently, making a massive shift in how we control our digital footprint. The May 2027 deadline. Large corporations are scrambling to meet the full compliance deadlines, making DPDP a boardroom priority rather than just an IT issue. The Act is famous for its teeth. Unlike previous laws, the DPDP Act introduces staggering penalties for data breaches, which is up to Rs 250 crores or $30 million for failing to implement security safeguards and up to 200 crores for failing to notify the data protection board or users about a breach. The sheer scale of these fines has put every major app and service provider on high alert. The Act is also trending due to a major legal battle. Information activists have recently moved the Supreme Court arguing that the DPDP Act inadvertently kills the rights to information or RTI. The conflict is that the critics argue the government is using privacy as a shield to deny RTI requests about public officials, potentially creating a surveillance regime while reducing transparency. What are the new rights for data principals? That is you. For the first time, the Indian citizens have legally enforceable rights over their digital data, which is fueling public interest. You also have the right to erase. You can demand that an app deletes your data once you stop using their services. You have right to nominate. You can appoint someone to manage your data rights in case of death or incapacity. You also have no forced consent. Companies can no longer trick you into giving data for one service like a flashlight app that wasn't necessary for its function. Then you have the SDF factor. The government is currently identifying significant data fiduciaries or the SDFs, which are large platforms like social media giants and e-commerce stores. These entities face much stricter rules, including mandatory independent audits and the appointment of a data protection officer based in India, which keeps these tech giants in the news. Now, we come to the legal challenge to the DPDP Act 2023. Venkatesh Nayak versus Union of India 2026 is the landmark Supreme Court case challenging the constitutionality of the Digital Personal Data Protection or the DPDP Act 2023 and its 2025 rules. The case is being held as the battle of rights as it pits the right to information (RTI) against the right to privacy. What is the core of the dispute? The most controversial part of this case is Section 44, subsection 3 of the DPDP Act. This section amended the RTI Act, Section 8(1)(j) in a way that transparency activists call a death knell for democracy. First, we come to privacy test. In the old RTI, the personal information could be denied if it had no relationship with public activity. In the new RTI, after DPDP, there is a blanket ban on all the personal information. All personal information is now exempt from disclosure. Second is public interest. In the old RTI regime, the information could be released if larger public interest justified it. But now in the new RTI, there is no override. The public interest exemption has been effectively removed. Official scrutiny. Citizens could ask for assets, education, or travel details of the public officials in the older RTI. Whereas there is a total shield on such informations now. Such details can now be denied simply by labeling them as personal. Key arguments by Venkatesh Nayak. Venkatesh Nayak, a veteran RTI activist, and other petitioners, including the reporters' collectives, have raised several constitutional objections. The first objection is that the RTI is weaponized. They argue that the government is using privacy intended to protect citizens from corporations as a shield to hide the corruption and the wealth of public officials from the public. The second objection is surveillance concerns. The petition challenges Section 17(1)(c) and Section 17(2) of the DPDP Act, which allows the government to exempt its own agencies from the Act for reasons like state security. Nayak argues that this creates a surveillance state with zero oversight. The third objection is lack of independence. The case challenges the Data Protection Board or the DPB. Nayak argues that because the government controls the appointment of the board, it cannot be an impartial judge when the government itself is the biggest data collecting entity. The fourth objection is impact on journalism. Investigative journalists argue that if they need to get consent from the person they are investigating as mandated by the Act, then investigative journalism in India will become impossible. On February 16, 2026, a three-judge bench led by Chief Justice Suryakant admitted the plea and issued a notice to the Union government. A constitution bench has been created recognizing the gravity of the clash between the two fundamental rights. The Supreme Court has referred the matter to a five-judge constitutional bench. The matter is scheduled for March 23, 2026. The court has notably refused to grant an interim stay, meaning that the Act remains fully operational while the case is being heard. Stay tuned with me as I will be following this case keenly in future also. If you liked my video, then please press the like button and hit the bell icon. That way you will get notification of all my new videos. And do not forget to subscribe to my channel. Hi, I'm Vishwajit and you are watching Landmark Cases.